But among these 7 states from which we had fake electors, it's a lot of fake electors, right? I mean, 16 of them already charged in Michigan, more of them being investigated as we speak, at least in Arizona and in Georgia, maybe in other places as well. It's a good reminder that in all these investigations that we are following around particularly the efforts to overthrow the results of the 2020 election, it's not just former President Donald Trump who's in the crosshairs. For example, in Special Counsel Jack Smith's classified documents case, charges have, of course, already been brought against Trump and also his staffer, Walt Nauta. But we also have reporting that another Trump Organization employee has been told that they're the target of that investigation and could face additional criminal charges. Again, so yet another person could be charged in the classified documents case. A person has been warned of charges, effectively given a target letter in that case. And while we have yet to see any charges in the January 6th case, in the overturning the election part of the case, one of the statutes reportedly listed in the target letter that Trump has received on that is conspiracy. And if there's one thing we know about conspiracy charges, it's that a person cannot conspire alone. Are there more names to drop? And what would that mean for the likely progress of these cases? Joining us now is Chuck Rosenberg. He's a former U.S. attorney and senior FBI official. If Trump is charged with conspiracy, and again, we should say we have reporting about what's in his target letter. Even if we had definitive knowledge of what was in the target letter, there's no guarantee that what's in the target letter is indicative that charges will be brought, or that the charges that will be brought are those that are related to the statutes mentioned in the target letter. I have to give you all the caveats. But with all those caveats, if Trump is charged with conspiracy, there's no guarantee that his conspirators, people he conspired with, would be charged under the same indictment or indeed charged at all, right?
That's exactly right. One can be an unindicted co-conspirator. In fact, if you think back to Michael Cohen's charges in the Southern District of New York, Cohen, of course, Mr. Trump's former personal lawyer, in that indictment, we learned about an unindicted co-conspirator. Individual one is how the government described that person in the indictment, and that turned out to be Mr. Trump himself. You know, charging a case as a conspiracy confers on the government certain evidentiary advantages. I'm not going to bore you with those now. So it makes sense often to charge a conspiracy, and often when you charge a conspiracy, you have multiple defendants at trial. But to your point, Rachel, you're exactly right. You don't have to. You can have unindicted co-conspirators that are flagged by the grand jury and mentioned in the indictment, but not sitting next to the defendant, perhaps Mr. Trump, at his own criminal trial.
Chuck, I have to ask you, I can't let you go without asking you one last question, which is the question on everybody's mind in the news business this week, which is what our expectations should reasonably be about the relationship between that reported target letter and any indictment and any unsealing of an indictment against Trump if one is in fact coming.
Yeah, another great question. Well, when I was a federal prosecutor, I would occasionally send out target letters. I would never send out a target letter to somebody that I did not intend to indict. They're not bluffs, they're not games, they're not make-believe. So here's what you ought to expect. If Mr. Trump really did receive a target letter, then he will be charged with federal crimes. If he really received a target letter, that will happen relatively soon. Now, to your points earlier, your caveats are wise. Target letters are not contracts, and the government could change its mind. But in my experience, that would be unusual. What you should expect is a federal indictment of Mr. Trump and a federal indictment soon.
Alabama's legislature appears poised to do something very, very radical to make sure that black voters in Alabama cannot elect representatives of their choice. You may have heard the Supreme Court of the United States. This may have crossed your radar. The Supreme Court of the United States, you might know, right now is a very conservative body. A 6-3 hard right conservative majority on the nation's highest court as we speak. But even so, even that hardline conservative 6-3 court could not swallow the recent decision by Alabama's legislature to draw up congressional districts in that state. So there's only one black majority district in the whole state, in a state where a quarter of the population is black. The High Court ordered the state of Alabama to make a new map where there are 2 such districts where black voters might be able to elect a representative of their choice. They have been ordered to do this by the federal courts. Alabama is refusing to do it, even though Alabama technically is a state in the United States of America, which is a country that is technically subject to the rulings of the Supreme Court of the United States. Even the Alabama parts of the United States are subject to federal court orders. But apparently they're deciding on this issue that they maybe don't want to be. Alabama deciding it just might not follow federal court orders when it comes to black people voting in 2023. It's not like a rascally little tantrum that Alabama is throwing here. This is the whole point of the country kind of stuff. This is as serious as it gets. I mean, defying federal court orders, to state the obvious, that is a fast drive down a short road for any country. And any state in the Deep South, any state that, say, seceded during the Civil War, is very, very well aware of that. They are very well aware of how radical this is. But of course, it's even more resonant, it's even more incendiary to do it right now, because Governor Slavery was not that bad DeSantis really does not look like he's going to go the distance in the Republican nominating contest. He's just running a terrible, terrible campaign that's sort of getting worse and more expensive by the day. He seems to be the only person who ever had a prayer of being within shooting distance, proverbial shooting distance, forgive me, of the Republican frontrunner. I mean, the Republican Party really does look poised to renominate its frontrunner, to renominate the candidate who is dominating all their presidential polling by 20, 30, 40 points. And if nobody can get anywhere near him, if they do renominate Donald Trump as their candidate for president, that means the whole campaign for president, the whole election for president of the United States over the course of this next year is going to be, in large part, a referendum on this question of whether we follow court orders anymore as a country, whether the legal system binds us, whether it binds all of us. Because the likely Republican nominee for president, as things are going, the prohibitive favorite to be the Republican nominee for president, he is facing a trial in October on a $250 million civil fraud case brought by the New York Attorney General, then another civil trial in January on defamation claims related to sexual assault allegations against him, then another civil trial later in January on a multi-million-dollar civil fraud case related to an alleged pyramid scheme type thing that he was involved in, then a criminal trial in March on the New York State hush money charges, then a federal criminal trial in May on his federal felony criminal indictment for his handling of classified documents, and meanwhile, we're waiting on news of additional potential criminal indictments of him personally, both at the federal level and in the state of Georgia, related to his efforts to overthrow the government and stay in power after he lost re-election. So if that's the, personal schedule of the Republican Party nominee for president, A, busy, and B, the election is going to be about this. It's going to be the referendum question posed both implicitly and explicitly by his candidacy. Do we choose him or do we choose law? Do we choose the law? Does the law apply to us all? Does it protect us all? Does it constrain us all? Or do we want this guy instead? And all of the myriad things he has to offer. This is an amazing story. I can't believe this is real. It's real. This is the Republican Attorney General of Texas. His name is Ken Paxton, although he is not currently serving as Attorney General because he has been suspended from office by the Texas legislature pending an impeachment trial. Now, how bad do things have to be for the Republicans in the Texas legislature to impeach their own Republican Attorney General? Well, where do we start? Almost the entire time he's been Attorney General, he's been under indictment for felony securities fraud. Meanwhile, he's facing potential disbarment from the practice of law entirely over his efforts to overturn the results of the 2020 election. Also, he's under criminal investigation by the U.S. Justice Department on serious corruption allegations. Allegations so serious that 8 high-ranking officials in his own office went to the FBI to report what they had witnessed in his office. Earlier this year, Paxton reached a multi-million-dollar settlement in a lawsuit for allegedly firing several of those officials as retaliation for them going to the FBI. It has been a lot with this guy. But hilariously, it was only when Paxton demanded that Texas taxpayers fork over the millions of dollars to pay that settlement that Republicans in the legislature finally started to get a little bit cranky with him. The Texas House impeached Ken Paxton by an overwhelming margin. So that means the Texas Senate now has to put him on trial. They'll hold an impeachment trial in September. If he's convicted at that Senate impeachment trial, he will lose his job permanently. Now, here's where it gets amazing. That trial will be presided over by the president of the Senate, the lieutenant governor of the state, a man named Dan Patrick. As the presiding judge overseeing Paxton's impeachment trial, he'll have immense power. He'll be the ultimate arbiter of, like, the rules and the admissibility of evidence and all that stuff. Here's the thing I can't believe is real, but it is. So Dan Patrick, the guy who's the presiding judge in this impeachment trial, just had to release his new campaign finance report. And would you look at that? He just received $3 million from the Ken Paxton Super PAC. Wow, what a coincidence. Dan Patrick isn't even up for re-election until 2026. All he has coming up is this impeachment trial that he has to run in a few weeks. And here's the PAC for the defendant in that impeachment trial dumping $3 million on his porch. Just ahead of the trial. Wow, everything is bigger in Texas. Amazing.
This map captures it's like a checklist of non-compliance. There was never any intent in this building to comply with that court order. Never. Also, there was never any intent in this building to comply with the Voting Rights Act.
That was Alabama state lawmaker Chris England speaking on Friday, a Democrat lodging one final objection as Alabama Republicans defied an order from the United States Supreme Court to fix a very problematic congressional map. Last month, the Supreme Court found Alabama in violation of the Voting Rights Act. In Alabama, 1 in 4 voters is black, but Republicans in the legislature cleverly constructed the state's congressional districts, so only 1 of 7 congressional districts in the state is majority black. That was too racially discriminatory, even for this hard-right conservative United States Supreme Court. And so the court ordered Alabama to redraw the lines so black voters would make up the majority or something quite close to it in 2 congressional districts, not just 1. To that, Alabama Republicans just basically said, no, we won't do it. They did draw new lines for new districts, but the new lines don't include anything like a new majority black district. So what does this mean? I mean, the sort of best case terrible scenario here is that Alabama Republicans are trying to stretch this out as long as possible to try and give themselves another shot at holding another election with illegal, racially discriminatory maps that favor Republicans. That's the best case terrible scenario. The worst case terrible scenario is that Alabama Republicans are just deciding that they don't recognize the authority of the federal government and federal courts. And that, of course, brings back all sorts of bad memories about what Alabama is capable of. But when we're about to have a presidential election in which the central question is likely to be whether or not we as a country follow the law, whether the law applies to everyone, this is a particularly incendiary move by Alabama Republicans. One that Alabama Democrats like State Rep Chris England have been raising to everyone. This is a particularly
in this building to comply with the Voting Rights Act.
That was Alabama state lawmaker Chris England speaking on Friday, a Democrat lodging one final objection as Alabama Republicans defied an order from the United States Supreme Court to fix a very problematic congressional map. Last month, the Supreme Court found Alabama in violation of the Voting Rights Act. In Alabama, 1 in 4 voters is black, but Republicans in the legislature cleverly constructed the state's congressional districts, so only 1 of 7 congressional districts in the state is majority black. That was too racially discriminatory, even for this hard-right conservative United States Supreme Court. And so the court ordered Alabama to redraw the lines so black voters would make up the majority of or something quite close to it in 2 congressional districts, not just 1. To that, Alabama Republicans just basically said, no, we won't do it. They did draw new lines for new districts, but the new lines don't include anything like a new majority black district. So what does this mean? I mean, the sort of best case terrible scenario here is that Alabama Republicans are trying to stretch this out as long as possible to try and give themselves another shot at holding another election with illegal, racially discriminatory maps that favor Republicans. That's the best case terrible scenario. The worst case terrible scenario is that Alabama Republicans are just deciding that they don't recognize the authority of the federal government and federal courts. And that, of course, brings back all sorts of bad memories about what Alabama is capable of. But when we're about to have a presidential election in which the central question is likely to be whether or not we as a country follow the law, whether the law applies to everyone, this is a particularly incendiary move by Alabama Republicans, one that Alabama Democrats like State Rep Chris England have been raising the alarm about.
One thing that I always say about Alabama, it continues to be the place where the dead bury the living. We're haunted by a ghost of the past. And every time we get to a critical juncture where our better angels could lead us in a proper direction, we refuse and we say, we dare defend our rights.
Joining us now is Chris England. He is a Democratic member of the Alabama House of Representatives. Representative England, I really appreciate you making time to be here tonight. Thank you.
Thank you for having me.
I'm going to ask you about those 2 scenarios that I just mentioned there. Do you think that Alabama Republicans are just sort of playing for time and knowing they're going to lose this, but they're dragging it out as long as possible? Or do you think they really are making an attempt to resist or nullify this federal court order?
I think it's a host of different things. I think at the bare minimum, it's an attempt to protect status quo. But at the worst of it all, I think it's an attempt to also buy time to use this legal map for 2 more years. But the other part of it is, I think it's an extension of the work that was done to eliminate Section 5 of the Voting Rights Act in the Shelby County case to now maybe using this non-compliant, defiant map to go back to the Supreme Court and hopefully convince the justices that, we're all conservatives here, so throw us a bone and maybe finish off Section 2 of the Voting Rights Act as well.
So if the Supreme Court was already willing in the Shelby County case to gut the Voting Rights Act by getting rid of Section 5, but Section 2 still exists, you think they may be doing this basically to tee up a case that would throw out the rest of the Voting Rights Act, that would throw out Section 2 as well?
Oh, no, I don't doubt it. I think it's a long legal strategy that ultimately buys them either time or makes another argument to go after Section 2. But on the other hand, it also throws the entire map to 1 or 2 people. A special master will draw it, and we basically shirked our constitutional responsibilities to represent our constituents and use them essentially as collateral damage for a political cause. And it was actually driven by people who don't even live here. If you remember, I don't know if you've heard this or not, but the Speaker of the House, McCarthy, called the Senate sponsor of the map and told him he's interested in keeping his majority. But I think Alabama citizens were probably more interested in the state keeping up to its obligations and following the law.
Kevin McCarthy encouraging defiance of the federal courts in order to eke out more illegally defined Republican-leaning districts obviously has disturbing national implications, but so does just saying that court orders don't matter, that if the federal courts are going to stand up and tell states what to do, states have an option to disobey those orders. I wonder, Representative England, what's been the reaction among Alabama voters, among your constituents, among black voters in Alabama in general, as this fight has played out the way it has?
Disappointment, disgust, but not surprised. There's interesting context here that many African Americans who occupy elected spaces in Alabama are representing districts that are majority minority and that were created by court orders from lawsuits that were filed years ago. The 7th Congressional District itself was a district created by a lawsuit and a court order. And interestingly enough, not only is the Black voting age population in the newly created 2nd Congressional District 39%, but the 7th Congressional District, this was created by a court order for the specific purpose of electing an African American, saw its Black voting age population in this new map go from 55% to 50%, which is just another, just an outright slap in the face if you're considering the fight and the history that Alabama shares with the rest of the country in terms of courts and the federal government having to force Alabama to do the right thing in situations like this. So it is not surprise, but still disappointment in the fact that Alabama once again gets to this crucial threshold and fails to do the right thing.
Alabama State Representative Chris England. Sir, thank you for joining us tonight. I know this is not over. We'd love to have you back and keep us surprised as this fight keeps playing out.
Oh, yeah, anytime. I got a lot more to say.
Good. All right, we'll have you back, sir.